Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. Divorce laws and retirement plan regulations are highly complex and vary significantly by state jurisdiction and individual plan specifications. You should not act or refrain from acting on the basis of any content included in this video without seeking the appropriate legal or other professional advice on the particular facts and circumstances at issue from an attorney or financial advisor licensed in your state. This content is intended to provide general historical trends and case studies, not a roadmap for your specific situation. Please conduct your own due diligence before making any decisions regarding your marital assets or retirement accounts. Imagine working for 35 years, rising before the sun in the humidity of a Georgia morning or the dry heat of West Texas, watching your 401k balance grow from a few $1,000s to a seven-figure nest egg. You've skipped vacations, driven the same truck for a decade, and maximized your employer match with the singular goal of a quiet retirement on the coast or in the hills. Then, in a single afternoon in a mahogany-paneled courtroom, a judge signs a decree that instantly carves that lifetime of discipline in half. For many in the American South, the 401k isn't just a retirement account. It is the single largest liquid asset in the marriage, often dwarfing the equity in the family home. We are currently witnessing a massive demographic shift known as the Great Divorce, where couples over the age of 50 are splitting at record rates. In the southern United States, where traditional values often intersect with complex community property laws and equitable distribution statutes, the battle over the 401k has become the primary theater of war. If you think your retirement is safe because the account is in your name alone, or because you earned every penny of it through your own labor, you are operating under a misconception that could cost you hundreds of thousands of dollars. In this deep dive masterclass, we are going to deconstruct the exact mechanics of how retirement assets are divided in southern jurisdictions. You will learn why a 401k is treated differently than a house, how the federal law known as ERISA overrides state preferences, and why the specific date you got married might be the most expensive number in your life. We are solving the mystery of the QDRO, the Qualified Domestic Relations Order, and explaining why this one document is the only thing standing between you and a massive IRS penalty. Whether you are in a community property state like Texas or Louisiana, or an equitable distribution state like Florida or North Carolina, this breakdown will provide the clarity you need to understand the potential outcomes of your financial future. To understand the 401k in a southern divorce, we must first address the cultural and legal landscape of the region. The American South presents a unique challenge because it contains a mix of two very different legal philosophies regarding marital property. On one hand, you have Texas and Louisiana, which are community property states. Historically, these jurisdictions view a marriage as a complete economic partnership. In these states, the starting assumption is that every dollar put into a 401k during the years of the marriage belongs equally to both spouses, regardless of whose name is on the statement. On the other hand, you have states like Alabama, Georgia, Tennessee, and the Carolinas which follow equitable distribution. In these states, the split isn't necessarily 50-50. A judge has the discretion to divide assets in a way they deem fair, which can be influenced by factors like the length of the marriage, the age of the spouses, and even their future earning capacity. Consider a case study from the suburbs of Charlotte, North Carolina. A high-earning executive at a financial firm has a 401k valued at $1.2 million. He married his spouse 20 years ago, but he started the account 5 years before the wedding. In an equitable distribution state, the court must first perform a process called classification. They have to peel back the layers of that $1.2 million to determine what is separate property and what is marital property. The portion of the 401k that existed before the wedding day, along with the passive growth on that specific portion, might be classified as separate. However, every contribution made during the 20 years of marriage, including the employer match and the growth on those contributions, is considered marital. In the South, where many families follow traditional structures with one primary breadwinner and one spouse managing the household, the equitable split often leans toward a significant portion being awarded to the non-working spouse to ensure they are not left destitute in their later years. The complexity deepens when we look at the ERISA factor. ERISA, or the Employee Retirement Income Security Act of 1974, is a federal law that governs most private sector 401k plans. This is a critical point that many people miss. Federal law generally preempts state law. This means that even if a state judge says you get half of your spouse's 401k, the plan administrator at the company, whether it's Coca-Cola in Atlanta or Exxon in Houston, cannot simply cut you a check based on a standard divorce decree. They require a specific legal instrument called a Qualified Domestic Relations Order, QDRO. The QDRO is a highly specialized court order that creates or recognizes the existence of an alternate payee's right to receive all or a portion of the benefits payable with respect to a participant under a retirement plan. Without a properly drafted QDRO that is approved by both the court and the plan administrator, the 401k remains locked. Historical trends show that many divorces are finalized on paper, but the QDRO is never filed or is drafted incorrectly. Years later, when the participant tries to retire or passes away, the ex-spouse discovers they have no legal access to the funds they were promised. In the South, where legal traditions can be formal and rigorous, the failure to secure a QDRO is one of the leading causes of post-divorce litigation. Let's look at the potential outcomes regarding taxes, which is where many Southern retirees face their biggest shock. A 401k is a pre-tax environment. If a judge awards a spouse $500,000 from a 401k, that is not the same as $500,000 in a savings account. That money is burdened by a future tax liability. If the recipient spouse takes the money as a cash distribution instead of rolling it over into their own IRA, the IRS will step in. Under typical circumstances, a withdrawal from a 401k before age 59 and a half triggers a 10% early withdrawal penalty plus ordinary income tax. However, there is a specific exception under Section 72T(2) C of the Internal Revenue Code. If the distribution is made pursuant to a QDRO, the 10% penalty is often waived for the recipient, though the income tax still applies. This nuance is often missed in the heat of a divorce settlement, leading to a situation where one spouse thinks they are getting a windfall, only to see 30% or more of it vanish to the federal government. Furthermore, we must address the traceability issue, which is particularly prevalent in the South, where families often have multi-generational wealth or long-tenured jobs at legacy Southern companies. If you entered a marriage with a 401k already in progress, the burden of proof is on you to prove what was yours before the I-dose. In legal terms, this is often called the hunt for the inception of title. If you cannot produce the statements from 20 or 30 years ago showing your starting balance, a Southern court may default to assuming the entire account is marital property. Historical trends in states like Alabama show that judges are increasingly strict about documentation. If the records are lost to time or a defunct record keeper, the potential outcome is a loss of your premarital credit. This is why this deep dive is essential. We aren't just talking about numbers on a screen. We are talking about the legal architecture of your future. In the following sections, we will break down the specific strategies for valuation, the dangers of offsetting a 401k against a house, and the unique ways Southern judges view fault in a divorce, such as adultery, and how that may or may not impact the division of your hard-earned retirement. This is the reality of the 401k divorce in the American South, a landscape where federal mandates meet state traditions, and where the prepared mind is the only true protection for your golden years. The transition from understanding the legal theory to applying the mathematical reality begins with the concept of classification. In the American South, where many marriages span decades and involve career paths at long-standing industrial or agricultural firms, the 401k is rarely a simple bucket of money. It is a timeline of a person's professional life. To divide it fairly or equitably, the court must first perform a financial autopsy. This is where the concept of traceability becomes the primary weapon in the courtroom. Imagine a man named Jackson living in Chattanooga, Tennessee, in this year of 2026. Jackson has worked for the same logistics company since 1998. He married his spouse, Linda, in 2008. When they file for divorce today, his 401k sits at a balance of $950,000. Jackson assumes that the 10 years of contributions he made before he ever met Linda are his separate property and therefore untouchable. However, in the legal climate of 2026, historical trends show that the burden of proof rests entirely on Jackson. He must provide what is known as the inception of title. This requires him to produce account statements from 1998 through 2008 to prove exactly what was in the account on the day he said "I do." But here is the reality of modern record keeping. Most plan administrators only maintain digital records for 7 to 10 years. Jackson's paper statements from the late 90s are likely sitting in a landfill or lost in a basement. Without those specific numbers, A Tennessee judge may look at the $950,000 and, because it has been commingled with marital contributions for 18 years, declare the entire amount marital property. This is a potential outcome that catches thousands of Southern retirees off guard every year. They lose the credit for a decade of hard work because they lacked a 3-page document from 20 years ago. Even if Jackson can prove his starting balance, he faces the hurdle of active versus passive appreciation. Let us say he proves he had $100,000 in the account in 2008. Over the next 18 years, that $100,000 grew because the stock market went up. That is passive growth. But during those same 18 years, Jackson was also contributing new money from his marital salary, and his employer was matching it. That is active growth. In many Southern jurisdictions, the passive growth on a separate asset might remain separate property, but the active growth is almost always marital. Calculating the intersection of these two forces requires a forensic accountant, adding thousands of dollars to the legal bill before a single cent is even divided. Now consider a different scenario involving a couple in Charleston, South Carolina, whom we will call David and Sarah. They are trying to be civil. They want to avoid a long court battle, so they look at their two biggest assets: a family home with $500,000 in equity and David's 401k, which is also worth $500,000. They decide on a clean swap. Sarah keeps the house and David keeps his retirement. Feels like a perfect 50-50 split. In reality, David has just signed away nearly 30% of his net worth without realizing it. This is what financial experts call the offset trap. In 2026, Sarah's $500,000 in home equity is a high liquidity asset. If she sells the house, she can utilize the primary residence capital gains exclusion to keep nearly every dollar of that equity tax-free. David's $500,000 in his 401k is a massive future tax liability. Every time David withdraws a dollar in retirement, the IRS and the state will take a portion as ordinary income tax. Based on historical trends and current tax brackets, David's $500,000 is actually worth about $350,000 in spending power. By agreeing to a dollar-for-dollar swap, David essentially gave Sarah a $150,000 bonus for leaving. Case studies from across the South show that many pro-SE litigants, those representing themselves, make this mistake daily because they view all dollars as equal. They are not. We also have to account for the volatility of the 2026 economy. When a divorce begins, a date of valuation must be set. Is it the day of separation? The day the divorce was filed? Or the day the judge signs the final decree? In a fast-moving market, this choice can be the difference between a comfortable retirement and a financial disaster. Imagine a couple in Birmingham, Alabama. On the day they separate, the husband's 401k is worth $1.2 million. 6 months later, as they are sitting in mediation, the market has dipped, and the account is worth $1 million. If the settlement agreement is written to give the wife a flat $600,000 based on the separation date value, the husband is now losing 60% of his remaining account rather than the 50% he intended. This is why professional scriptwriters and legal experts emphasize using percentages rather than fixed dollar amounts in retirement settlements. In the South, there is also the unique intersection of 401k division and alimony, often referred to as spousal support. In states like Florida or North Carolina, a judge might look at a 401k not just as an asset to be split today, but as a source of future income that could mitigate or increase the need for alimony. If one spouse receives a larger share of the retirement account, the court might reduce the monthly alimony check or vice versa. This creates a complex chess match where the 401k becomes a bargaining chip for long-term lifestyle maintenance. Take the case of Mary, a stay-at-home parent in rural Georgia. Her husband has a high-balance 401k from a career in the energy sector. Mary has no retirement savings of her own. In 2026, Georgia law follows equitable distribution. The judge will not just look at the 401k balance. They will look at Mary's ability to earn a living now that the marriage is ending at age 55. Because Mary sacrificed her career growth to support the family, the judge may award her 60% of the 401k to ensure she has a baseline of security that she cannot otherwise build in the 10 years remaining before retirement. This shift from 50-50 to a needs-based split is a hallmark of Southern judicial discretion. However, even if the judge awards Mary that 60%, the money does not just move from one account to another. It enters a state of legal limbo. This leads us to the most dangerous phase of the entire process, the actual movement of the funds. Many people assume the divorce decree is the final word. They walk out of the courthouse thinking the deal is done. But the 401k plan administrator at a major corporation does not work for the state court. They work under federal ERISA guidelines. To them, your state divorce decree is nothing more than a piece of paper. If you fail to follow the exact, highly technical steps of the next phase, you could end up in a situation where the account remains in your ex-spouse's name for years. And if they happen to pass away or take a loan against the account before the transfer is finalized, your share could vanish into a black hole of litigation and federal tax penalties. You are standing on the edge of a financial canyon, and the only bridge across is a document that most lawyers hate to draft because one misplaced comma can ruin the entire transfer. But what happens when the 401k isn't the only retirement asset? What if there is a pension, a Roth IRA, and a 401k all tangled together? And more importantly, what is the one secret weapon that plan administrators use to reject your paperwork and keep the money locked away for months or even years? We are going to expose the hidden mechanics of the QDRO rejection cycle and the tax-saving strategies that the wealthy use to move retirement money without giving the IRS a single cent. We will cover that in the next part. To understand the hidden mechanics of the QDRO rejection cycle, you have to look at the plan administrator as the final boss of your financial divorce. Imagine a man named Robert in Jackson, Mississippi, in this year of 2026. Robert has spent 30 years at a major regional utility company. His 401k is his pride and joy, valued at $800,000. His divorce settlement states that his ex-wife, Susan, is entitled to exactly 50% of the account as of the date of their separation. Robert and Susan sign the divorce decree, the judge stamps it, and they think the ordeal is over. But when Susan sends that decree to the plan administrator, she receives a cold 3-sentence letter stating that the order is not qualified and cannot be honored. This is the beginning of the QDRO rejection cycle, a loop that can take months or even years to escape. Plan administrators are not looking for fairness. They are looking for strict adherence to the terms of the plan summary description. In 2026, many Southern corporations have outsourced their plan management to massive third-party financial institutions. These institutions use automated systems that flag any document that does not use their specific, proprietary language. If your lawyer used a generic template from a legal database instead of the specific model language provided by the employer, the document will be rejected. This rejection doesn't just delay the payment, it leaves the assets exposed to Robert's future financial decisions. If Robert decides to take a massive loan against his 401k while the QDRO is stuck in the rejection loop, Susan's 50% share might be calculated against a much smaller remaining balance, leading to a secondary legal battle over whether Robert committed a breach of fiduciary duty. To avoid this, a masterclass level strategy involves the pre-approval process. Before the judge ever signs the QDRO, the draft must be sent to the plan administrator for a preliminary review. This step is often skipped in the rush of a Southern divorce, but in 2026, it is the only way to ensure the transfer happens smoothly. Historical trends show that orders that go through pre-approval are processed 60% faster than those that do not. During this phase, the administrator will check for technical errors such as the exact legal name of the plan. If the document says the Robert Smith Retirement Plan instead of the Regional Utility 401k Savings Plan, it is an automatic rejection. They will also look for the specific method of calculation. Does 50% mean 50% of the balance on a specific day? Or does it include the earnings and losses on that share from the date of separation until the date of actual distribution? In a volatile 2026 market, that distinction can represent a swing of tens of thousands of dollars. Now let's talk about moving the money without the IRS taking a massive bite. This is where the wealthy utilize the direct rollover. Imagine a woman named Elena in Atlanta, Georgia. She is the alternate payee receiving $400,000 from her ex-husband's 401k. She has two main options. Option 1 is to take the money as a cash distribution. Because she is receiving this money via QDRO, the IRS will waive the 10% early withdrawal penalty, even if she is under the age of 59 and a half. However, she will still owe federal and state income tax. In 2026, with Georgia's tax brackets and federal rates, Elena might see $120,000 vanish instantly. Furthermore, the plan administrator is legally required to withhold 20% for federal taxes right off the top. Option 2 is the secret weapon of the financially savvy: the direct rollover to an individual retirement account or IRA. By instructing the plan administrator to transfer the funds directly into her own IRA, Elena avoids all immediate taxation. The money remains in a tax-deferred environment, allowing it to continue growing for her future. She becomes the master of her own financial ship, choosing her own investments rather than being stuck with the limited options in her ex-husband's employer plan. This is a critical step in the American South, where the cost of living is rising, and preserving every cent of principal is vital for long-term survival. However, there is a technicality that many people overlook regarding Roth 401ks. In 2026, it is increasingly common for workers to have both a traditional 401k and a Roth 401k within the same employer plan. If the QDRO simply says divide the 401k, it may not specify which subaccounts are being accessed. Roth money is post-tax and much more valuable than traditional pre-tax money. If Elena's lawyer doesn't specify that she wants a pro rata share or a specific portion of the Roth side, she might end up with only the traditional, tax-burdened funds, while her ex-husband keeps the tax-free Roth assets. This is the level of detail required in a deep-dive masterclass. You must account for the color of the money, not just the amount. Another advanced concept is the choice between a separate interest QDRO and a shared interest QDRO. For most 401k plans, a separate interest order is the gold standard. This essentially carves out a piece of the account and hands it to the ex-spouse as if it were their own. They can name their own beneficiaries and decide when to take distributions. But in some older Southern Company plans or certain pension-style 401ks, you might be forced into a shared interest order. This means you only get a portion of each check the participant receives. If the participant dies early, your income could stop entirely. Understanding which type of plan you are dealing with is the difference between a lifetime of security and a sudden financial cliff. Historical trends in 2026 also show a rise in what we call the QDRO tax trap for the participant. If the QDRO is drafted poorly and the participant is forced to withdraw the funds to pay the ex-spouse rather than the plan transferring the interest directly, the participant could be the one stuck with the tax bill. Imagine Robert in Mississippi again. If the order is written incorrectly and he has to take a distribution to pay Susan, the IRS may view that as Robert's income. He could find himself in a higher tax bracket, losing his deductions, and owing a massive sum at the end of the year, all because the paperwork didn't specify the alternate payee's tax responsibility. As we navigate the complexities of 2026, we also have to look at the impact of 401k loans. This is a pandemic in the Southern workforce. Many employees take loans against their 401k to pay for a child's college or a home renovation. In a divorce, these loans are considered an asset that has already been spent. If Robert has a $200,000 balance but a $50,000 outstanding loan, the court has to decide if that loan is a marital debt or Robert's personal debt. If the judge decides it was for the family, Susan might only get 50% of the remaining $150,000, essentially paying for half of Robert's loan. If the judge decides it was separate, Susan gets her half of the full $200,000, leaving Robert with a much smaller slice of the pie. The movement of this money is a delicate dance of federal law, state court orders, and corporate bureaucracy. But what happens if the participant tries to sabotage the process? What if they quit their job to trigger a payout, or worse, what if they pass away before the QDRO is finalized? There is a specific legal safety net that can protect you from these nightmare scenarios, but most people don't know it exists until it's too late. We are going to reveal the survival strategies for the gap period and how to protect your interest from a vengeful ex-spouse who wants to burn the house down just so you can't have the kitchen. We will dive into the protection of death benefits and the impact of the surviving spouse decree in the next part. The period between the day a judge signs your divorce decree and the day the 401k plan administrator officially approves your qualified domestic relations order is known among legal professionals as the danger zone. In this year of 2026, with the speed of digital transactions and the complexity of federal oversight, this gap period has become a graveyard for retirement dreams in the American South. If you are sitting in a lawyer's office in Nashville or Richmond, you might feel a sense of relief when the final papers are signed. You believe the deal is done. However, in the eyes of federal law and the Department of Labor, you are in a state of extreme legal vulnerability. Until that QDRO is marked qualified by the plan, the participant, your ex-spouse, still holds the keys to the kingdom, and the consequences of a single life event during this window can be catastrophic. Imagine a case study involving a man named William in Charlotte, North Carolina. William has worked for a major bank for 25 years and has amassed $1.2 million in his 401k. His divorce from his wife Sarah is finalized in March 2026. The court awards Sarah 50% of the account, Sarah's attorney tells her they will get around to drafting the QDRO in a few weeks. In April, tragedy strikes. William is involved in a fatal car accident on I-85. Because the QDRO was never finalized and submitted to the plan administrator, the 401k plan still lists William's beneficiary as the primary recipient of the funds. But wait, you might think Sarah was the beneficiary on the account for 20 years. Here is the historical trend that destroys families. Upon divorce, many southern states have statutes that automatically revoke a spouse's status as a beneficiary. However, ERISA, the federal law governing 401ks, often preempts these state laws. If William had updated his beneficiary to his new girlfriend or his brother the day after the divorce, or if the plan defaults to his estate, Sarah could be left with zero, despite what her divorce decree says. This brings us to the critical concept of the surviving spouse decree. To protect yourself in 2026, a masterfully drafted QDRO must include specific language that names the alternate payee, the ex-spouse, as the surviving spouse for the purposes of the plan's death benefits. This is not a default setting. There are two types of survivor benefits you must account for: the Qualified Pre-Retirement Survivor Annuity, or QPSA, and the Qualified Joint and Survivor Annuity, or QJSA. If your QDRO does not explicitly state that you retain these rights even after the divorce is final, and the participant passes away before you receive your distribution, the plan administrator may legally refuse to pay you a single cent. We have seen case studies where ex-spouses in Georgia and Alabama lost hundreds of thousands of dollars because their legal counsel failed to check a single box regarding survivor benefits. They assumed the divorce decree was a shield. In reality, without the QDRO, it was a sieve. But what if the threat isn't death, but a vengeful ex-spouse who is very much alive? This is the reality of the sabotage strategy. Imagine a woman named Elena in Birmingham, Alabama. Her ex-husband, Marcus, is furious about the 50-50 split of his $600,000 401k. He knows it will take months for the QDRO to be processed. In a fit of spite, Marcus logs into his employee portal in May 2026 and takes the maximum allowable loan against the account, $50,000, and spends it on a non-refundable luxury cruise and a new truck. When the QDRO finally reaches the administrator in August, the account balance is no longer $600,000. It is $550,000, and there is a lien against the remaining funds. Elena's 50% share has just shrunk by $25,000. To prevent this potential outcome, savvy litigants in 2026 are using the freeze letter and the joinder. A freeze letter is a formal notice sent to the plan administrator as soon as a divorce is filed. While not all plans will honor a simple letter, many major Southern employers, from Delta in Atlanta to FedEx in Memphis, have protocols to place a temporary hold on loans and hardship withdrawals once they are put on notice of a pending domestic relations matter. In some jurisdictions, your lawyer can seek a preliminary injunction or a status quo order from the judge, which legally forbids the participant from touching the 401k during the proceedings. In California, this is automatic. In the South, you often have to fight for it. If you don't ask for the freeze, you are essentially leaving your retirement vault wide open while the person you are suing holds the only key. Let's look at the data regarding the success of these protective measures. Historical trends in 2026 suggest that individuals who file a joinder, a legal process where the 401k plan itself is joined as a party to the divorce lawsuit, have a significantly higher rate of asset preservation. When the plan is a party to the suit, they are under a direct court order to notify both parties of any attempted changes to the account. This effectively shuts down the sabotage strategy. However, many Southern attorneys avoid joinders because they are procedurally complex and involve serving papers to out-of-state corporations. But in a deep dive masterclass, we have to be honest. If your 401k is the majority of your net worth, the procedural complexity is a small price to pay for the security of knowing the money will actually be there when the QDRO is approved. There is also the issue of the 401k's investment shell. In a volatile 2026 market, the way your share is defined in the QDRO can lead to wildly different results. If the order says Sarah gets $500,000, and the market crashes while the QDRO is in the 3-month approval loop, the participant, William, bears the entire loss. He might be left with only $100,000 while Sarah gets her full $500,000. Conversely, if the market booms, Sarah gets no part of the gains. This is why we see a trend toward pro rata distribution. This means Sarah gets 50% of the account, plus or minus the investment earnings or losses attributable to her share from the date of separation until the date of distribution. This is the only way to ensure that both parties share the market risk. Without this language, you are essentially gambling on the timing of a corporate bureaucracy. Now, consider the successor spouse complication. Imagine Marcus in Alabama remarries in July 2026, while the QDRO for his first wife, Elena, is still sitting on a desk at the plan administrator's office. Under ERISA, his new wife immediately gains certain rights to his retirement benefits. If Marcus were to die before Elena's QDRO is qualified, the plan administrator is now faced with two competing claims. The first wife with a state court decree, and the second wife with federal statutory rights as the current spouse. This creates a legal nightmare known as an interpleader action, where the 401k company sues both wives and lets a federal judge decide who gets the money. Case studies show these battles can take years to resolve, during which time the 401k is frozen and being drained by legal fees. This gap period is the most dangerous time in a Southern divorce, yet it is the time when most people are at their most exhausted and least vigilant. They stop checking their mail, they stop calling their lawyers, and they assume the system will take care of them. But the system is a machine of rules, not a provider of fairness. You must be the one to drive the QDRO to the finish line. But even if you survive the gap and the money is finally moved, you aren't out of the woods. There is a specific high-stakes decision you have to make the moment that money hits your account. If you make the wrong choice, you could trigger a massive tax bill that you can never take back. And for those in the South who are over the age of 50, there is a hidden rule in the tax code that could be your greatest ally or your worst enemy, depending on how you structure your first withdrawal. We are going to break down the immediate cash-out trap and the 10% penalty exception that only applies during a divorce, which could save you tens of thousands of dollars in a single move. That is coming up in the next part. The moment the plan administrator stamps your qualified domestic relations order as qualified, a unique and narrow window of opportunity opens. This is a moment of profound financial gravity that most retirement savers will never experience in their lifetime. Under normal circumstances, the Internal Revenue Service is a jealous guardian of retirement funds. If you attempt to touch your 401k before the age of 59 and a half, the government typically levies a 10% early withdrawal penalty as a deterrent. However, in the specific context of a divorce in the American South, or anywhere in the United States, Section 72T. 2C of the Internal Revenue Code creates a specific exception. This is the one-time golden window where the alternate payee, the spouse receiving the funds, can access cash without that 10% sting. But here is the trap. If you make one wrong move with the paperwork, that window slams shut forever, and you could cost yourself tens of thousands of dollars in unnecessary penalties. Imagine a case study involving a woman named Emily in Greenville, South Carolina. In this year of 2026, Emily has just finalized her divorce after 22 years of marriage. As part of the equitable distribution, she has been awarded $300,000 from her ex-husband's 401k. Emily is 45 years old. She finds herself in a position common to many newly single people in the South. She is asset-rich but cash-poor. She needs to secure a new home, pay off $25,000 in legal fees, and create a cushion for her transition back into the full-time workforce. Emily's first instinct might be to roll the entire $300,000 into a fresh individual retirement account to keep it safe. This seems like the responsible conservative move. However, if Emily rolls that money into an IRA, and then discovers 2 months later that she needs $50,000 for her down payment, she has just walked into a financial buzzsaw. The moment the money touches an IRA, the QDRO exception under Section 72T vanishes. When she withdraws that $50,000 from her IRA, the IRS will hit her with a $5,000 penalty on top of the ordinary income tax. Historical trends show that thousands of Southerners make this mistake every year because they believe the divorce exception follows the money. It does not. The exception stays at the 401k level. To utilize this strategy, Emily must take the cash distribution directly from the 401k plan at the time the QDRO is being processed. This leads to the sophisticated hybrid move that we see employed by high-net-worth individuals in Atlanta or Nashville. Instead of choosing between all cash or all rollover, you can split the distribution. Emily could instruct the plan administrator to pay her $75,000 in a direct check and roll the remaining $225,000 into her IRA. This allows her to access the liquid capital she needs for her fresh start, while bypassing the 10% penalty, while still preserving the majority of her wealth for her future. But even in this scenario, Emily must be prepared for the mandatory withholding. By federal law, the plan administrator must withhold 20% of any cash distribution for federal income taxes. If Emily asks for $75,000, she isn't going to get a check for $75,000. She is going to get a check for $60,000, while $15,000 is sent directly to the IRS. In 2026, many people are shocked by this. They plan their new life based on the gross amount, only to find their net check is significantly smaller. Furthermore, that 20% is just a down payment on the tax bill. Depending on Emily's total income for the year, including her share of the 401k, she might actually owe the IRS 32% or more. This is the potential outcome that requires a deep dive calculation with a tax professional before the QDRO is even signed. Consider another layer of complexity: the state tax implications in the South. While states like Florida or Tennessee have no state income tax on wages, they may have different rules for retirement distributions or high-value assets. In states like Georgia or North Carolina, the state will want its slice of that 401k distribution. If you are living in a jurisdiction with a 5 or 6% state tax rate, your $300,000 award is quickly starting to look like $200,000 of actual spending power. Now let's look at the scenario for someone slightly older, the rule of 55. Imagine a man named David in Little Rock, Arkansas. David is 56 years old and is going through a divorce in 2026. He is the participant in the 401k, not the recipient. He is also leaving his job as part of a retirement package or a career change. Under the rule of 55, if an employee leaves their job in or after the year they turn 55, they can take penalty-free withdrawals from their current 401k. However, this does not apply to their old 401ks from previous employers. In a Southern divorce where a participant might have multiple retirement accounts from a long career across different companies, the strategy for which account to tap first becomes a mathematical puzzle. If David's legal team isn't aware of the interplay between the QDRO exception for his wife and the rule of 55 for him, they might liquidate the wrong assets, triggering penalties that could have been easily avoided. There is also the psychological trap of the cash distribution. In the American South, where traditional values often emphasize property ownership and family legacy, the sudden influx of 6 figures into a bank account can lead to emotional spending. Case studies from 2026 show a rising trend of revenge spending, or lifestyle inflation, immediately following a 401k payout. People buy the boat they were never allowed to have or take the luxury trip to the Gulf Coast to forget their troubles. But every dollar taken out of that tax-deferred environment today is a dollar that cannot compound for tomorrow. At an average market return, $50,000 left in a 401k for 15 years could grow into nearly $150,000. Taking the cash out now doesn't just cost you the tax, it costs you the future growth. We must also discuss the technicalities of the 1099-R form. When you take a distribution via QDRO, the plan administrator will issue a 1099-R at the end of the year. This form will have a distribution code in box 7. For a QDRO distribution that is exempt from the penalty, the code is typically 2. However, administrators make mistakes. If they code it as a standard early distribution, the IRS computers will automatically generate a bill for the 10% penalty. You must be prepared to file Form 5329 with your tax return to claim the exception and prove the distribution was made pursuant to a valid QDRO. Without the documentation to back this up, you are at the mercy of an automated tax system. This brings us to a critical realization. The 401k is not just a pile of money, it is a collection of different types of assets. And in the South, where many major employers are headquartered, from the shipping giants in Memphis to the beverage titans in Atlanta, there is one specific type of asset inside many 401ks that is the single most powerful tax-saving tool in existence. It is called Net Unrealized Appreciation, or NUA. If your 401k contains stock in your own company, and you divide it without understanding the NUA rules, you are likely throwing away the chance to pay low capital gains rates instead of high ordinary income tax rates. But NUA is a double-edged sword. If you move the stock into an IRA, the NUA benefit is destroyed instantly. If you sell the stock inside the 401k and then move the cash, the benefit is destroyed. In 2026, as the stock market sees record-breaking movements, the NUA strategy is the difference between keeping 70 cents of every dollar or keeping 90 cents. We are about to dive into the elite-level strategy of company stock distribution and how the wealthy in the South are using it to effectively divorce the IRS along with their spouse. We will also explore what happens when the 401k isn't just stocks, but holds alternative assets like real estate or private equity, which is becoming a major trend in 2026. The complexity of the valuation for these assets can bring a divorce to a grinding halt for years. We'll cover the NUA Holy Grail and the alternative asset nightmare in the next part. The net unrealized appreciation or NUA strategy is often referred to by financial planners in the South as the Holy Grail of tax planning, because it allows you to fundamentally change the way the government views your wealth. To understand why this is a massive factor in 2026, we have to look at the massive corporate presence in southern hubs like Houston, Charlotte, and Atlanta. Imagine a man named James who has worked for a major energy corporation in Houston for 30 years. Over those 3 decades, the company offered a 401k match in the form of company stock. In 2026, James's 401k is valued at $2 million, but $1 million of that is purely in shares of his employer's stock. In a standard divorce, most people would simply divide the $2 million and roll their respective shares into IRAs. However, James's cost basis on that $1 million of stock, meaning the price the company actually paid for those shares over the last 30 years, is only $100,000. If James or his ex-spouse, Patricia, rolls that stock into an IRA, they are making a decision that will eventually subject the entire $1 million to ordinary income tax rates, which in 2026 could be as high as 37%. But if they utilize the NUA strategy through their QDRO, the potential outcome changes dramatically. Here is the step-by-step breakdown of how the NUA Holy Grail works in a Southern divorce. First, the QDRO must specifically identify the employer stock and order it to be distributed in kind to a taxable brokerage account rather than a tax-deferred IRA. When this happens, Patricia only pays ordinary income tax on the cost basis, the $100,000. The remaining $900,000 of growth is classified as net unrealized appreciation. This $900,000 is not taxed at the time of distribution. Instead, when Patricia eventually sells the stock, it is taxed at the long-term capital gains rate, which is significantly lower than ordinary income tax. In 2026, this move alone can save a divorcing spouse hundreds of thousands of dollars in taxes. Historical trends show that this is one of the most underutilized strategies in Southern courtrooms because many family law attorneys simply do not have the specialized tax training to recognize the opportunity. Patricia could walk away with a much larger net share of the marital estate simply by understanding the color of the money she is receiving. However, the NUA strategy requires surgical precision. If Patricia sells even one share of that stock while it is still inside the 401k plan, the NUA eligibility for that share is destroyed. If the QDRO is written to transfer a dollar amount rather than a specific number of shares, the plan administrator might liquidate the stock to fulfill the order, effectively nuking the tax benefit. This is why in 2026, the collaboration between a divorce attorney and a certified financial planner is not a luxury. It is a necessity for anyone with significant company stock holdings. While the NUA strategy represents the pinnacle of tax efficiency, we must also confront the opposite end of the spectrum, the alternative asset nightmare. In the year 2026, more Southerners than ever have moved away from traditional stocks and bonds, choosing instead to hold alternative assets within self-directed 401ks. We are talking about gold bullion, shares in private healthcare startups in Nashville, or fractional ownership of apartment complexes in the booming markets of North Florida. While these investments can be lucrative, they are a logistical disaster in a divorce. Imagine a case study involving Linda and Robert in Raleigh, North Carolina. Robert's 401k holds a $250,000 stake in a private equity fund that invests in regional timberlands. As they head into their divorce in 2026, Linda is entitled to half of that asset. But here is the problem. Private equity is illiquid. You cannot simply sell a fractional share of a timberland investment on a public exchange to pay out an ex-spouse. Furthermore, the valuation of such an asset is highly subjective. Robert's appraiser might say the timberland is worth $200,000 because of a recent dip in lumber demand, while Linda's appraiser might argue it is worth $400,000 because the land has future development potential for suburban housing. This leads to what we call appraisal fatigue. In 2026, Southern courts are being bogged down by these valuation gaps. If the parties cannot agree on a price, the judge may be forced to order a professional valuation, which can cost upwards of $10,000 and take months to complete. Even once a value is established, the question of how to divide it remains. If the 401k plan does not allow for the in-kind transfer of private equity to an alternate payee, which many do not, Robert may be forced to buy out Linda's interest using other marital assets. He might have to give her $125,000 more from the family home equity, or a larger share of the liquid cash, just to keep his illiquid timberland investment intact. This creates a high-stakes game of financial chicken. If Robert doesn't have the liquid cash to buy Linda out, he might be forced into a fire sale of the asset, potentially losing a massive amount of value just to satisfy the court order. Historical trends in 2026 show that alternative assets are the primary reason divorces among the wealthy are taking twice as long to finalize as they did a decade ago. Every piece of private debt, every cryptocurrency holding, and every real estate syndicate share in a 401k adds a layer of complexity that can bring the entire legal process to a grinding halt. Then there is the issue of the double dip. In many Southern jurisdictions, there is an ongoing legal debate about whether a retirement asset can be counted twice, once as an asset to be divided, and again as a source of income for calculating alimony. If Robert's alternative assets in his 401k are generating $20,000 a year in passive income, Linda might argue that she should get half the asset today, and that Robert's income should be calculated including that $20,000 for her future spousal support. Case studies from Alabama and Tennessee show that judges are increasingly wary of this, but the rules are far from settled in 2026. As we navigate these high-level financial structures, we are forced to realize that the 401k is not just a retirement account. It is a multifaceted legal entity. But there is one sector of the Southern population that faces an even more rigid and complex system than the corporate 401k. We are talking about the millions of active-duty military members and veterans stationed at massive bases like Fort Liberty in North Carolina or Fort Moore in Georgia. Their version of the 401k, the Thrift Savings Plan or TSP, operates under an entirely different set of federal rules that can make a standard corporate QDRO look like child's play. What is the one mistake military members make that allows their ex-spouses to claim a portion of their retirement they never earned? And why does the 2026 update to the blended retirement system mean that everything you thought you knew about military divorce is now obsolete? We are going to go inside the high-security world of the TSP and the specific federal forms that can override even the most ironclad state divorce decrees. The battle for the military 401k is about to begin, and the rules of engagement have changed. We will cover the TSP minefield and the military retirement revolution in the next part. The Thrift Savings Plan, or TSP, is the federal government's version of the 401k. And in the American South, it is a cornerstone of family wealth. With massive installations like Fort Liberty in North Carolina, Fort Moore in Georgia, and the sprawling naval presence in Norfolk, Virginia, military retirement accounts are frequently the largest contested asset in a Southern divorce. However, if you walk into a courtroom in Fayetteville or Savannah, thinking the same rules that apply to a corporate 401k will protect your military nest egg, you are walking into a legal minefield. In this year of 2026, the intersection of the new blended retirement system and the federal frozen benefit rule has created a landscape where a single miscalculation can result in a service member losing hundreds of thousands of dollars in future value, or a spouse being left with a fraction of what they were led to expect. To understand the 2026 reality of a TSP divorce, we must first address the death of the time rule. For decades, Southern courts used a simple mathematical formula to divide military retirement. They would wait until the service member actually retired, look at their final high-3 salary, and then give the ex-spouse a percentage based on how many years the marriage overlapped with the military service. This was known as the wait-and-see approach. However, due to the National Defense Authorization Act of 2017, the federal government mandated a shift to the frozen benefit rule. This rule is now the standard in 2026. Under this mandate, the value of the retirement benefit for divorce purposes is frozen at the rank and years of service the member had on the day the divorce was finalized. Imagine a case study involving a major named Michael stationed at Fort Liberty. Michael has been in the Army for 12 years and has been married to Alicia for all 12 of those years. They are finalizing their divorce in May 2026. Under the old rules, if Michael stayed in for another 8 years and retired as a colonel, Alicia would have received a share of his colonel's pension. Under the 2026 frozen benefit rule, Alicia's share is calculated as if Michael retired today as a major with 12 years of service. Every promotion, every time and grade raise, and every cost of living adjustment Michael earns over the next 8 years belongs solely to him. In the high-stakes environment of military leadership, this represents a potential outcome where the ex-spouse loses out on the most lucrative years of a career's growth. Alicia's legal team must be incredibly precise in how they value the TSP versus the pension to ensure she isn't left behind as Michael's career accelerates. Furthermore, we have to look at the blended retirement system, or BRS, which most service members in 2026 are now enrolled in. Unlike the legacy pension system, the BRS includes an employer match into the TSP, exactly like a corporate 401k. This means the military retirement is now a two-headed beast: a defined benefit pension and a defined contribution TSP. In the American South, where many judges have traditional views on military service, there is often confusion about how to treat these two different pots of money. The pension is governed by the Uniformed Services Former Spouses Protection Act, while the TSP is governed by the Federal Employees Retirement System Act. You cannot use a single document to divide both. If Michael and Alicia's attorney drafts a retirement benefits court order for the pension but fails to file a separate, technical TSP document with the thrift line in Birmingham, Alabama, Michael keeps 100% of the TSP by default, regardless of what the judge said in court. This brings us to the Retirement Benefits Court Order, or RBCO. This is the federal government's version of the QDRO. The TSP administrators are notoriously rigid. Historical trends in 2026 show that nearly 40% of all court orders sent to the TSP are rejected on the first attempt because of minor phrasing errors. For example, if the order specifies a dollar amount instead of a percentage, the TSP may reject it if the account balance fluctuates before the order is processed. If the order mentions the word alimony instead of property division, it can trigger different tax withholdings that neither party intended. In the military culture of the South, where efficiency and protocol are paramount, the administrative bureaucracy of the TSP remains the ultimate gatekeeper. Let's look at a case study of a staff sergeant named Marcus in Georgia. Marcus has a TSP valued at $150,000. His wife, Janice, is awarded 50% of the marital portion. But Marcus has a $30,000 loan against his TSP that he took out to pay for the family's move to Fort Moore. In 2026, the TSP does not recognize loans as part of the divisible balance for the alternate payee. This means the TSP will only see a balance of $120,000. If Janice's order says she gets 50% of the account, she receives $60,000. Marcus is then left with $60,000 plus the obligation to pay back the $30,000 loan. He effectively ends up with $30,000 while Janice walks away with $60,000. This is the potential outcome when the debt isn't properly accounted for in the divorce decree. Marcus's lawyer must argue that the loan should be treated as a marital debt and offset elsewhere, or Janice will receive a windfall at Marcus's expense. We also have to debunk the 10-10 rule myth, which is rampant in military towns across the South. Many service members believe that if they were married for less than 10 years, their spouse cannot get any of their retirement. This is a dangerous misconception. The 10 out of 10 rule only dictates how the money is paid. If you were married for at least 10 years overlapping with 10 years of service, the Defense Finance and Accounting Service will send a check directly to the ex-spouse. If the marriage was less than 10 years, the court can still award the spouse a share of the retirement, but the service member has to write a personal check to their ex every month. This creates a lifelong tether between former spouses that can lead to endless litigation and conflict in 2026. Then there is the Survivor Benefit Plan, or SBP. This is the insurance policy that ensures the ex-spouse continues to receive a portion of the retirement if the service member dies first. In the American South, where many military families rely on the pension as their primary safety net, the SBP is a high-stakes bargaining chip. If the court orders Michael to maintain Alicia as the SBP beneficiary, that comes with a monthly premium that is deducted from Michael's retirement pay. Who pays that premium? In 2026, Southern judges often split the cost, but if the paperwork doesn't specify a gross pay or net pay division, Michael could find himself footing the entire bill for a benefit he will never receive. Finally, we must address the issue of disability pay. In the veteran-heavy populations of Alabama, Florida, and South Carolina, many retirees receive VA disability. Under federal law, VA disability is not divisible in a divorce. However, many retirees waive a portion of their taxable retirement pay to receive non-taxable disability pay, the VA waiver. If a service member does this after the divorce is final, it can drastically reduce the amount of money the ex-spouse receives. In 2026, we are seeing a rise in indemnity clauses where the service member agrees that if they take a VA waiver that reduces the spouse's share, they must make up the difference out of their own pocket. Without this clause, the spouse's retirement share can vanish overnight with a single trip to the VA office. The military TSP and pension system is a fortress of federal regulations that often stands in direct opposition to state court intentions. Navigating this in the South requires more than just a lawyer. It requires a strategist who understands the specific codes of the DFAS and the TSP. But as we move from the world of the military to the general public, there is another massive retirement asset that is often completely forgotten until it is too late to claim. We are talking about the hidden value of Social Security and the state-specific quirks of the South that can either double your retirement income or leave you with a permanent deficit. What is the one date on the calendar that determines if you can claim your ex's Social Security without taking a penny from them? And why are Southern states suddenly changing the way they view separate property in 2026? We are going to expose the Social Security loophole and the new state laws that are rewriting the rules of the Southern divorce in the next part. The division of a 401k is a visible battle, a clash of statements and spreadsheets that plays out in the bright light of a mediator office. But as we move into the complexities of 2026, there is an invisible retirement asset that often carries more long-term weight than the 401k itself, yet it never appears on a qualified domestic relations order. We are talking about Social Security divorce spouse benefits. In the American South, where many households historically followed a model of one primary breadwinner and one spouse who managed the domestic sphere or worked in a lower earning capacity, this Social Security loophole is the difference between a retirement of dignity and a retirement of struggle. While a 401k can be depleted by market crashes or medical emergencies, Social Security remains a lifetime hedge against inflation. And in 2026, the rules for claiming it after a divorce have become a primary focus for Southern retirees. Imagine a case study involving a woman named Martha in Savannah, Georgia. Martha is 64 years old in this year of 2026. She and her husband George are finalizing a divorce after 28 years of marriage. George was a senior engineer at a major aerospace firm, while Martha worked part-time as a librarian while raising their children. During the divorce, they divided George's $1.5 million 401k exactly 50-50. Martha feels secure with her $750,000, but she is worried about her monthly cash flow. Because her own career was interrupted, her personal Social Security benefit is only $1,200 a month. George's benefit, however, is $3,600 a month due to his decades of high-bracket contributions. Under federal law, Martha is eligible for a divorced spouse benefit, which allows her to receive up to 50% of George's full retirement age benefit. In this case, that is $1,800 a month, $600 more than her own benefit. Here is the part that often shocks Southern couples. Claiming this benefit does not take a single penny away from George. It does not reduce his check, and it does not reduce the check of a future wife if George decides to remarry. It is a separate federal entitlement. However, Martha must meet the magic date requirement. To qualify, the marriage must have lasted at least 10 consecutive years. Historical trends in 2026 show a heartbreaking phenomenon known as the 10-year cliff. Imagine if Martha and George had filed for divorce at 9 years and 11 months. In the eyes of the Social Security Administration, Martha would be entitled to 0% of George's benefit. We are seeing case studies where spouses in South Carolina or Tennessee are literally counting the days until their 10th anniversary before serving divorce papers, specifically to secure this lifetime benefit. If you are at the 9-year mark in 2026, rushing to the courthouse could be the most expensive mistake of your life. There is also the 2-year waiting period that catch many by surprise. If George is eligible for Social Security but has not yet applied for it because he wants to wait until age 70 to maximize his check, Martha can still apply for her share of his benefit if they have been divorced for at least 2 continuous years. This is a critical 2026 strategy for the lower-earning spouse. It prevents the higher earner from using their Social Security as a weapon of financial control by refusing to retire. In the South, where traditional power dynamics can sometimes linger in long-term marriages, this federal rule provides a necessary level of independence. However, we must address the remarriage trap. If Martha remarries in 2027, she generally loses the right to claim benefits on George's record. But if George remarries, Martha's right remains intact. This creates a strange incentive structure in the 2026 dating market for Southern seniors. Many are choosing to cohabitate rather than legally remarry to preserve their access to an ex-spouse's higher Social Security bracket. It is a pragmatic response to the economic realities of 2026, where the cost of healthcare and housing in southern hubs like Charlotte or Nashville continues to outpace fixed incomes. While Social Security provides a federal safety net, the state legislatures in the South are simultaneously rewriting the rules of separate property in 2026. We are witnessing a massive shift in how states like North Carolina and Florida view the growth of a 401k. For decades, the rule was simple: what you brought into the marriage was yours, and the growth on it was usually yours. But new 2026 statutes are moving toward a more aggressive definition of active appreciation. Consider an imagine-if scenario where George started his 401k 5 years before marrying Martha. He had $100,000 in it on their wedding day. By the time they divorce in 2026, that specific $100,000 has grown to $400,000 through market appreciation alone. Under old rules, that $400,000 might be his separate property. But in 2026, Southern courts are increasingly looking at whether George made active management decisions during the marriage. Did he rebalance the portfolio? Did he move money from a target date fund into specific tech stocks? If he touched the account at all, a 2026 judge in Alabama or Georgia might rule that he converted that separate growth into marital property because his marital efforts, his time and expertise, contributed to the growth. This is a potential outcome that is sending shockwaves through the Southern legal community. It essentially means that there is no longer a safe harbor for premarital 401k funds, unless they were left completely untouched in a stagnant fund for the duration of the marriage. The burden of proof has shifted. In 2026, it is no longer enough to show what you had at the start. You must prove that you did absolutely nothing to increase its value during the years you were married. Furthermore, we are seeing the rise of the double-dip defense in Southern courtrooms. This occurs when one spouse tries to claim a share of the 401k as an asset today, and then tries to claim the income generated by that 401k as part of George's ability to pay alimony tomorrow. In 2026, Florida recently passed legislation to curb this practice, stating that if an asset is divided in equitable distribution, the income from that asset cannot be used to calculate alimony. This is a massive victory for the person holding the 401k, but it requires a very specific legal argument to be made at the exact moment of the trial. If your lawyer misses the window to invoke the double-dip defense, you could end up paying for the same 401k twice. As we look at these layers, the federal Social Security benefits, the state laws on active appreciation, and the defenses against double-dipping, we see a landscape that is becoming increasingly hostile to the unprepared. The American South is no longer a region of simple 50-50 splits. It is a region of forensic accounting and legislative nuance. But there is one final piece of the puzzle that most people ignore until the very last day of their divorce. It is the issue of 401k beneficiary designations and the automatic revocation laws that vary wildly from state to state. What happens if you win the battle for your 401k, but you forget to change one name on a digital form? And why are Southern banks in 2026 suddenly refusing to honor state laws that are supposed to protect you after a divorce? We are going to reveal the beneficiary black hole, and the final checklist you must complete within 48 hours of your divorce being finalized, or risk losing everything you just fought for. We are entering the final stages of this masterclass, where the smallest details determine who actually keeps the money. We will cover the beneficiary trap and the 48-hour checklist in the next part. The reality of the beneficiary black hole is that it operates on a set of rules that are completely indifferent to your divorce decree. In this year of 2026, most individuals believe that a state court order is the final word on their financial life. They imagine that once the judge in Charleston or Birmingham signs the paper, a signal is somehow sent to every financial institution, automatically updating their records. In truth, the 401k operates within a federal fortress called ERISA, or the Employee Retirement Income Security Act. This federal law specifically mandates that a plan administrator must pay the person named on the beneficiary designation form, period. It does not matter if you were divorced for 20 years. It does not matter if your ex-spouse signed a waiver in the divorce decree promising they would never touch the money. If their name is on that form when you pass away, the plan administrator is legally obligated to hand them the check. This is not just a theory. It is a historical trend backed by the highest court in the land. The landmark case of Egelhoff versus Egelhoff established that ERISA preempts state law. Many southern states, including Alabama, Texas, and Virginia, have statutes known as revocation on divorce laws. These state laws were designed to protect people by saying that a divorce automatically revokes a former spouse's status as a beneficiary. However, because the 401k is a federal instrument, the Supreme Court ruled that these state laws are essentially invisible to the 401k plan. We have seen case studies in 2026 where a grieving second spouse discovers that the seven-figure 401k of their late husband is being paid out to the first wife because the paperwork was never updated. This is the beneficiary trap, and it is the single most common way that generational wealth is accidentally redirected in the American South. Imagine a man named Jackson living in Huntsville, Alabama, in 2026. Jackson has just finished a grueling divorce from his first wife, Linda. In the settlement, they agreed that Jackson would keep his entire 401k valued at $800,000. Jackson is exhausted and relieved. He puts the divorce papers in a drawer and moves on with his life. 2 years later, Jackson remarries a woman named Karen. He assumes that because Karen is now his legal wife, she is his natural heir. He never logs back into his 401k portal because he is busy with his new life. In late 2026, Jackson suffers a sudden health event and passes away. Karen goes to claim the 401k, but the plan administrator informs her that Linda is still the named beneficiary. Despite the divorce decree, despite the waiver Linda signed, and despite Jackson's subsequent marriage, the federal law requires the administrator to pay Linda. Karen is left with nothing but a mountain of legal fees as she tries to sue Linda's estate to get the money back. A process that is expensive, slow, and often unsuccessful in southern jurisdictions. To prevent this potential outcome, you must execute the 48-hour checklist immediately after your divorce is finalized. This is a masterclass-level protocol for securing your assets in the digital age of 2026. The clock starts the moment the judge's pen leaves the paper. You cannot wait for the certified copy to arrive in the mail. You must act with the same urgency you would use if you had lost your wallet. Step 1 of the 48-hour checklist is the immediate digital audit. Within the first 24 hours, you must log into every retirement portal you own. In 2026, security is tighter than ever, so ensure your multi-factor authentication is updated. Do not just check the primary beneficiary, you must check the contingent beneficiaries as well. Many people in the South name their spouse as primary and their spouse's siblings as contingent. If you only change the primary, you are still leaving your wealth exposed to your former in-laws. You must remove every name associated with your previous marriage and replace them with your new designations. Once you hit save, you must take a screenshot or a screen recording of the confirmation page. Digital records can glitch, and having a timestamped visual proof of your change is your secondary shield in 2026. Step 2 is the formal employer notification. Most 401k portals are managed by third-party providers like Fidelity or Vanguard, but your actual employer still holds a copy of your record. Within the 48-hour window, you must send an email to your HR department with the updated beneficiary information. In the South, where many major companies have been around for a century, there is often a lag between the corporate HR records and the digital portal. By notifying HR directly, you create a paper trail that exists outside of the financial institution's server. If a dispute arises later, your email to HR serves as evidence of your intent to change the beneficiary, which can be a critical factor in a 2026 federal court case. Step 3 is the coordination with your QDRO specialist. If the 401k is being divided, you are likely in the process of drafting a qualified domestic relations order. However, you must ensure that the QDRO does not conflict with your new beneficiary designations. For example, if the QDRO gives your ex-spouse 50% of the account, but your beneficiary form still lists them as 100%, you have created a legal contradiction that can freeze the account for years. In 2026, the complexity of these interactions is at an all-time high. Your lawyer and your QDRO drafter must be on the same page. You should explicitly ask them if the language in the QDRO provides for a successor spouse, or if it protects the participant's right to name a new beneficiary for their remaining share. Step 4 is the successor spouse protection. If you are the participant, you need to understand that the moment you remarry in 2026, federal law creates a new set of rights for your new spouse. Under ERISA, a current spouse is the automatic beneficiary of a 401k, unless they sign a written waiver. This means that if you try to leave your 401k to your children from your first marriage, your new spouse must legally agree to it in writing. This is a common point of friction in Southern families where there are children from multiple marriages. If you do not have that signed waiver from your new spouse, your children could be completely disinherited from your retirement assets by operation of federal law. The depth of this beneficiary trap is why so many Southern retirees feel like they are walking on eggshells even after the divorce is over. You are fighting against a system that values administrative efficiency over personal intent. The plan administrator does not care who you love or who you were married to. They only care about what is on the form. Historical trends show that the people who survive this process with their wealth intact are the ones who treat the administrative side of the divorce with the same intensity as the courtroom side. But even after the beneficiary forms are updated and the 48-hour checklist is complete, there is one final massive hurdle that can still derail your retirement. We have spent this masterclass looking at what happens during and immediately after the divorce. But what about the 5, 10, or 15 years that follow? There is a phenomenon known as the post-divorce audit, a lurking danger where the IRS or the plan administrator can come back years later to claw back funds or impose penalties for mistakes made in the original QDRO. And more importantly, there is the golden handcuffs problem. What happens when the division of the 401k makes it financially impossible for you to ever retire from the job you hate? We are going to wrap up this masterclass with the ultimate survival guide for the years after the split. We will reveal how to conduct your own post-divorce audit to ensure no mistakes are hiding in your records, and how to break the golden handcuffs to find a path to retirement that doesn't depend on your ex-spouse's future choices. This is the final piece of the puzzle, the culmination of everything we've learned about the 401k divorce in the American South. The finish line is in sight, and we are going to make sure you cross it with your future secured. That is all coming up in the final part. Crossing the finish line of a 401k divorce in the American South is not a moment of sudden stillness. It is the beginning of a new long-term financial trajectory. In this year of 2026, the complexity of the economy and the evolving legal standards in Southern jurisdictions mean that the work you do in the 5 years following your divorce is just as critical as the work you did in the courtroom. We have covered the classification of assets, the technicalities of the QDRO, the beneficiary traps, and the immediate tax implications. Now, we must address the reality of living with the result. For many in states like Tennessee, Alabama, or the Carolinas, the post-divorce era is defined by a phenomenon known as the shadow audit. Imagine a case study involving a man named Thomas in Richmond, Virginia. Thomas is 58 years old in 2026. His divorce was finalized 3 years ago, and he successfully divided his $900,000 401k with his ex-spouse. He followed the 48-hour checklist, updated his beneficiaries, and thought the book was closed. However, in early 2026, Thomas receives a notice from his plan administrator stating that a recent internal audit discovered a mathematical error in the way the earnings and losses were calculated during the 18-month gap between his separation and the final distribution. Because the stock market saw significant volatility during that period, the administrator claims they overpaid Thomas's ex-spouse by $42,000. In a potential outcome that feels like a nightmare, the plan administrator informs Thomas that they intend to recapture that money by deducting it from his remaining account balance, unless he can prove the original calculation was correct. This is the reality of the 2026 shadow audit. Plan administrators at massive Southern employers are increasingly using AI-driven auditing software to review past QDRO distributions for compliance and accuracy. If the original order was vaguely worded or if the plan's record keeper changed during the process, these errors can lie dormant for years. Historical trends suggest that the burden of proof in these disputes often falls on the participant. Thomas must now go back to his 2023 records, find the valuation statements, and potentially rehire his QDRO expert to defend his balance. This highlights the necessity of permanent record retention. You must keep every piece of paper related to your retirement division until you have completely emptied the account in your 80s or 90s. Beyond the technical audits, we must address the psychological and financial weight of the golden handcuffs. This is particularly prevalent in the Southern workforce, where long tenures at companies like UPS, Delta, or various utility monopolies are common. Imagine a woman named Diane in Atlanta, Georgia. Diane is 61 years old in 2026. After her divorce, her $1.2 million nest egg was split in half. She is left with $600,000. Before the divorce, Diane was planning to retire at 62 to spend time with her grandchildren in the North Georgia mountains. Now she looks at her balance and realizes that $600,000, especially with the 2026 cost of living, is not enough to sustain her desired lifestyle for 30 years. Diane is now wearing the golden handcuffs. She feels she has to stay in a high-stress job she no longer enjoys simply to rebuild her lost principal. However, in 2026, there are specific retirement catch-up strategies that are being utilized by savvy Southerners to break these handcuffs. The super contribution phase. In 2026, the IRS has adjusted catch-up contribution limits for those aged 50 and older. Diane can maximize her 401k contributions, but she can also utilize the Secure Act 2.0 provisions that allow for even higher catch-up limits for individuals aged 60 to 63. The Roth conversion pivot. If Diane's income is lower in the years immediately following the divorce, she might consider a strategic Roth conversion of a portion of her 401k. By paying the tax now at a lower bracket, she ensures that every dollar of future growth is tax-free, effectively stretching her $600,000 further than a traditional pre-tax account. Health Savings Account, HSA, as a stealth IRA. In the South, where healthcare costs are a major concern for retirees, Diane can maximize her HSA. In 2026, these funds can be invested in the market, grow tax-free, and be used for medical expenses in retirement, or even as a general retirement fund after age 65, subject to ordinary income tax. Historical trends in 2026 show that individuals who pivot to an aggressive, multi-layered savings strategy immediately after a divorce are often able to move their retirement date up by 3 to 5 years compared to those who simply continue their previous savings habits. We also have to discuss the final math verification. When the money is finally moved from the participant's 401k to the alternate payee's account, most people simply look at the final number and assume it is correct. But who did the math? In many cases, it was a clerk at a massive financial institution handling thousands of orders a week. You must perform a reconciliation audit the moment the funds hit your account. Step 1. The principal check. Did the base amount match the divorce decree or QDRO exactly? Step 2. The earnings and losses check. If the QDRO specified that the award should include interest and market gains/losses from the valuation date, you must ask for the calculation worksheet. If the market went up 10% during the processing time, but your award only reflects the original dollar amount, you have been shortchanged. Step 3. The fee check. Many 401k plans charge a fee for processing a QDRO, often ranging from $500 to $2,000. Does the decree specify who pays this? If the plan deducted the fee from your share when the judge ordered the other party to pay it, you need to seek an immediate adjustment. In the year 2026, these administrative slippages are becoming more frequent as plan management becomes more automated and less human. Case studies from North Carolina suggest that up to 15% of QDRO distributions contain a mathematical error of at least 1% of the total value. On a $500,000 transfer, that is $5,000 that belongs to you, not the plan. Finally, we must acknowledge the new normal of the American South. Divorce at 50 or 60 is no longer the social or financial ending it once was. It is a restructuring. The legal culture of the South, while rooted in tradition, is adapting to the 2026 reality of mobile workforces and digital assets. Whether you are in a community property state like Louisiana or an equitable distribution state like Florida, the potential outcome of your retirement is ultimately determined by your level of engagement. The 401k was designed to be a tool for personal freedom. In a divorce, it can feel like a source of entrapment. But by mastering the nuances we have discussed, from the inception of title and the QDRO rejection cycle to the Social Security loophole and the NUA Holy Grail, you are reclaiming that freedom. You are no longer a passenger in your own divorce. You are the architect of your second act. As we conclude this deep dive masterclass, remember that the American South is a place where family legacy and financial independence are deeply intertwined. Your 401k is the fruit of decades of labor in this region's heat, its cities, and its industries. Protecting it isn't just about the money. It's about protecting the time you have left. You have the tools, the checklists, and the knowledge of the 2026 landscape. Now go out and secure the future you worked for. But what happens when the 401k is only half the story? What if you are also dealing with a family-owned business, a farm that has been in the family for 3 generations, or a portfolio of rental properties in the booming southern suburbs? The intersection of retirement accounts and small business ownership creates a whole new level of potential outcomes that can either double your liability or provide a massive tax shield. We are preparing a new masterclass on the Southern Family Business Divorce, covering the valuation of private entities and the double dip trap for business owners. We will see you in that next deep dive.